Hello, everyone. Good afternoon. Welcome. Thank you so much for being here, both in person and online. To welcome you all here for the first distinguished lecture of the year with Professor Aziz Rana. Aziz Rana has distinguished himself through his remarkable research and insight into the intersection of constitutional law and American political culture, and he currently serves as a university professor of law and government at the Boston College Law School, where he teaches courses in constitutional law. This is a recent appointment, and it is one that has been a huge benefit for the student body already, as well as for the faculty. Professor Rana received his BA from Harvard. He earned his PhD there as well. He received a JD from Yale Law School. And as a distinguished and passionate political scientist, he has written many essays and op-eds also for the popular press, including the Washington Post, New York Times, as well as being a contributor to numerous law review articles, journals across the country. He has published 2 books that offer a unique blend of invaluable insight and analysis of constitutional ideals and democratic self-governance. His first book, The Two Faces of American Freedom, contextualizes key historical events in the context of race. And this fresh perspective revealed many of the limitations of early American understandings of economic and political freedom and liberty. And it also highlighted an ongoing struggle to define freedom as a universal right. And I would say that he's interested in the hard contours of freedom, of who may enjoy it, whom it has liberated, whom it continues to oppress. And in so doing, Professor Rana allows readers to rethink the narratives that surround American freedoms and identity. So his most recent work, which we are here to celebrate and launch today, and which will be available outside after the talk as well, is called The Constitutional Bind: How Americans Came to Idolize a Document That Fails Them. And in it, we'll hear about it, he explores the emergence of the modern admiration for the U.S. Constitution. And he brilliantly connects the widespread veneration of the document and its relative immutability to the rise of the United States as a global hegemonic power, first at the turn of the 20th century and then after the World War II to the present. And he sheds light on an array of social movements that have shaped our understanding of the Constitution. So, in my view, one of the major contributions of the Constitutional Bind is that it centers a new cast of characters who are frequently ignored in constitutional histories. So rather than focus mainly on the Supreme Court and the interpretations and arguments put forth by the justices and the presidents that have appointed them, this book brings to the fore the voices of workers, women, Black Americans, indigenous communities, intellectuals, and activists. And we learn about alternative visions that have coursed through the history of U.S. democracy. The reality of the settler foundations of our great nation is laid bare, and so are the obstacles that these alternative visions have faced throughout our history. From the crucial debate over whether or not to annex the Philippines to the emergence of a Socialist Party of America, from the constitutional understanding of Paul Robeson and the contributions of W.B. Du Bois and Martin Luther King, all the way up to the Revolutionary People's Constitutional Convention of the Black Panthers, and even through the little-known activism of Afeni Shakur, the mother of the artist Tupac. So it is the racially marginalized, the socioeconomically marginalized, they are here given their scholarly due. Aziz Rana thereby brings a sorely needed and sober look at where we are versus where we could have been. And he indicates where we can yet arrive in order to give these missing voices their constitutional due. Now, reading this erudite and impressive work of immense research, Aziz manages a delicate balance. You learn about many different aspects of US society and politics, including the somber sides that often escape scrutiny, and the surprising ways in which our global role has undercut many of our values. But the reader is also constantly reminded of the distance we have traveled. There's no reluctance to grant credit where credit is due. And the book takes the reader all the way up to the reform proposals of the current day on both the left and right. The constitutional bind is a powerful and necessary call for vigilance, and Professor Rana is rightly celebrated for his ability to connect the complexity of the Constitution to its hidden historical context, as well as to our current political discourse. And he has suggestions for improvements to expand what he calls the narrow constitutional narrative that, as he shows, has bound us very tightly. So as the director of a center dedicated to the study of constitutional democracy, I agree wholeheartedly with this endeavor to look anew at this document. I'm often trying to think of ways to make the Constitution relevant and meaningful. This is one of the civic education challenges for our era. For the past 3 years around Constitution Day, we've been asking BC students and faculty what the Constitution means to them. And there have been some brilliant appreciations by our undergraduate fellows, and during last year's edition, we were mesmerized when Aziz gave us a preview of some of his arguments, modeling for BC students and fellows how to grapple with accepted truths in an intellectually rewarding fashion. And to do this at an extremely sensitive and timely moment in the unfolding of our national narrative. So I'm so grateful that you are here today to do so at length for the Klaus Center's launch of this new volume, The Constitutional Bind, How Americans Came to Idolize a Document That Fails Them. Without further ado, please join me in extending a warm welcome to Aziz Rana.
So first, thank you so much, Jonathan, for that incredibly kind and generous introduction. And thank you as well for all of your work organizing today, as well as everyone else that was really involved in putting today together, including Chris and the other folks that are working on the video and the tech to make this happen. And thanks to all of you for being here as well, especially on a rainy day. I should say I feel especially grateful to the BC community as a whole, who've been so incredibly welcoming of me and supportive of my own scholarship and work as I've finished this book over the last couple years. And so I'm just deeply appreciative to have this opportunity to talk about the manuscript with all of you. And I think what I'm going to do for, let's say, 35 to 40 minutes is just give an overview of some of the elements of the argument of the book as a whole. And the book is really motivated by this sense of a basic tension between what we can think of as the political moment we're all experiencing in some way around the Constitution, and just the cultural experience of what living in the US has been with respect to the text. In a sense that there's a basic kind of, tension or sort of foundational confrontation, it seems, between the politics and the culture. So let's talk a little bit about the politics of the time. If you just read the New York Times or the Washington Post, or frankly, follow any of the debates that are swirling around, there's a growing sense that there's some pretty foundational problems with the Constitution, especially when it comes to its ability to represent all Americans in a fair and equal way. And we can think about this in terms of the fact that representation in the US seems organized less on the principle of one person, one vote, and more on the sort of foundational unit of the state, so geographic representation. And then this ends up influencing all of these different elements of our constitutional system. Because of the focus on states, we see this play out in terms of representation in the House, where states have the ability effectively to make determinations about how different districts get constructed. And so it might be the case that more people vote for one party in a particular state, but as it turns out, the folks that end up getting elected to Congress are overwhelmingly from the other party. And it's not just House of Representation, the House of Representatives. it also plays out in terms of basically all of the other elements of our federal electoral system. So we see this with the Senate, where we're moving toward a system where you might have something like 70% of the population only in 15 of the states. And so that the way that the Senate is constructed ends up having a huge emphasis on representation from folks in some parts of the country as opposed to others. We see this play out in the presidency, the increasingly common feature of having folks lose the popular vote but then end up elected as president. And then through those institutions, the Supreme Court, where the Supreme Court disproportionately overrepresents one of the parties as opposed to the other. There hasn't been, for instance, a Democrat nominated to the Supreme Court as Chief Justice since 1946. And we have a situation in the present where the, 4 of the 9 justices on the Supreme Court were nominated by presidents that had lost the popular vote. You can go on and on and on. At the same time, the fact that the Constitution itself is so difficult to amend, by some accounts it's the hardest document in the world to amend, means that just about all of our constitutional conversations end up flowing through the court. It's a kind of funnel that then limits the capacity to have broader discussions and conversations. So all of this should be familiar. I'm not the first person to say this. And yet, if you grew up in the United States at the end of the 20th century, at the beginning of this one, your experience of the Constitution would have been that it was a near ideal distillation of representative government. In other words, it was the perfect blend through its system of checks and balances and federalism of providing rights to minority groups, so various kinds of libertarian protections, along with some framework for the exercise of the free and fair vote, so principle of one person, one vote. And this seemed to me like a question that was a puzzle. How is it that we got to a place where, despite all of these very clear issues with the way that representation operated, the culture around the Constitution was, as the document, as near perfect? And the argument that I ended up developing over the course of the book is that we tend to think of venerating the Constitution as something that has been with the country from the very founding, that hasn't really changed in any particular way. But in truth, constitutional support and the particular language around describing the Constitution as near perfect has actually changed quite dramatically over time. There have been real ebbs and flows in the American relationship to the document. And in particular, the way that Americans talk today about the Constitution is a 20th century development, and it's a product of a set of processes that are almost never thought of alongside the story of the US Constitution. In particular, it's very closely tied to how, as Jonathan noted, the US emerged as a global power, and then over the course of the 20th century really rose from being a regional authority in the Americas to a globally hegemonic project. And that in order to understand the culture around the Constitution and its impact for the kind of conversations we're having politically, we actually have to link together a story of the Constitution's development alongside the story of the US's growth and development, especially when it comes to international politics. And this means doing something that's quite unusual when we think of our own Constitution. We think of constitutions as domestic documents, as tied to nations. And yet, to understand the domestic story, we have to tell a story that is fundamentally global and international, that links the foreign and the domestic. So for the rest of my time, what I'm going to try to do is just very briefly work through elements of the book's argument. So what do I mean by constitutional support? What are its basic components? Then talk a little bit about what American constitutional culture was like before the consolidation of our modern venerative approach. Then work very quickly through what the historical argument of the book is, and end with some reflections for the present, both as a matter of scholarship and then also as a matter of making sense of this tension between the political and the cultural. All right, so what do I mean when I'm talking about constitutional support? The central concept of the book is something I called Credal constitutionalism. And it's a very specific way that Americans have come to describe their relationship to the text. that there are many different forms of potential constitution worship or critique, but in the 20th century, a specific story of the Constitution and how it's tied to American national identity ended up becoming dominant. And it had a series of components that, if you just take a step back, need not go together. So first was the idea that the Constitution fulfills the basic principles of the Declaration of Independence. In other words, it is a concrete instantiation of the idea that the U.S. from the founding has been committed to principles of freedom and equality for all, so that the creed is tied to the Constitution. I use the creed here because it's the term that the Swedish sociologist Gunnar Myrdal, in his famous book, American Dilemma, referred to as defining sort of the national story, connected it to the Declaration of Independence. It goes back to Lincoln, to Frederick Douglass, to anti-slavery and abolitionist arguments, even that preceded the Civil War. But so this is the idea of the creed. Yet over the course of the 20th century, it's not just that the Constitution stands for the principles of the Declaration of Independence. There are a series of other things that we just take for granted. First, we take for granted the idea that the Constitution is a civil libertarian document. And in this way, it is anti-totalitarian. In other words, it highlights what differentiates the US culturally from the Soviet Union or Nazi Germany. In other words, the Constitution protects a sphere of individual autonomy for speech, for religious worship, that ensures preservation of what amounts to one's own freedoms from an overweening state authority. And this civil libertarian commitment is also very interestingly tied to an account of economic liberty, where within the kind of private sphere that's supposed to be outside the terms of the state, there's also assumed to be an economic sphere, one's access to property, and that this is something that precedes government intervention, and that even if there's an appropriate place for economic regulation, there are certain bedrock property rights that ensure an economic liberty that's preserved against the state. And so civil liberties and economic liberties are joined in this way, that it's not just the creed, but it's a civil libertarian ethos that's also a commitment to some limited version, but nonetheless an account of market capitalism. And then all of that is interestingly tied to a defense of representative government, but of constrained representative government. This is the stuff of the checks and balances, which is, yes, ultimately, consent of the governed is the basis for American politics. It's the legitimate source of political authority. But nonetheless, the U.S. is organized around a set of checks and balances that ensure against what's called a tyranny of the majority, and that the ultimate site, in some way, of that preservationist project is the Supreme Court as an insulated institution that preserves these checks and balances, that ensures against tyranny of the majority. So you have a strong defense of constrained representative government tied to an account of the Supreme Court. And then finally, all of that speaks to why the U.S. is understood as exceptional, why the U.S. is viewed as distinct from the rest of the world, why its constitution can be thought of as near perfect, and at the same time, why therefore on a global stage marked by various forms of instability, past imperial orders, the U.S. has the right and the authority to serve as the leader among equals, to be the backstop of a global rules-based order, to step inside and outside of legal arrangements to ensure that that rules-based order is preserved. So just notice, we started with support for the Constitution. But really, like when you hear politicians of both political parties, so this could be Obama or Bush or McCain, talk about the Constitution, it's this constellation of commitments. And none of them necessarily have to go together. You can believe in the Constitution, as folks in the American past did, and reject the creed, just reject an idea of universal equality. You can believe in the creedal Constitution, the connection between the Declaration and the text, but be suspicious of arguments from a kind of civil libertarian ethos or a defense of market capitalism or an account of American authority on the global stage. And yet all of these different disparate elements have been fused in American culture into a single coherent story about nation and text that's something that's part of the drinking water of being American. That's what we hear in speeches, what we understand as part of the civics education of public schools, universities, more generally. And just to highlight the novelty, in a way, of what emerges in the 20th century, it's useful to just juxtapose it against what would have been the dominant way of talking about the Constitution and why it's worthy of support 100 and, let's say, 70 years ago, in the years in the North, in Massachusetts, but before the Civil War. Here, the dominant story would have probably come from somebody like Daniel Webster, so senator out of Massachusetts, who said, yes, the Constitution is worth venerating and defending, but it's worth defending as a compromise, the compromise of 1787. In other words, it was a compromise between the different regions of the country. It was a compromise especially over the question of slavery. It allowed communities in different parts of the country to avoid addressing the thorny question of enslavement so as to ensure national growth, material prosperity, and territorial growth. Take a moment and just sort of like step back from this story. Note, this is fundamentally different than our contemporary creedal one. And if anything, it's almost the exact opposite of the contemporary creedal one. This is a story that would have been quite dominant in American life that says the Constitution is worth defending because it means we can avoid addressing slavery. Now that's, for us today, that's a profound moral and political failure and sin. The idea that you have a set of institutions that don't confront the basic foundational injustice that marks collective life. Or that the reason why it's justified is it allows us to avoid addressing slavery so we can engage in territorial expansion. What is that? But that's forcing us to come face to face with a history of Native American removal and the treatment of Native Americans. That's not a justification for the constitutional system. That's yet another profound injustice that has to be reckoned with. And so it requires us now to think about how is it that the culture changed so dramatically, and what has that meant for our own contemporary politics? Now, on the one hand, and this is one of the arguments of the book that Jonathan noted, this is a profound victory for this country, that today we live in a world in which our understanding of constitutional meaning in the national ethos is a basic rejection of what would have been bedrock commitments during the antebellum period. It's a defense, effectively, of multiracial democracy. And yet, as I started, there are these percolating questions about the extent to which the institutions, as well as the venerative culture around us, around those institutions, is actually fulfilling the terms of what multiracial democracy should and would look like in the present. All right, so just a bit more on what was the climate around the Constitution in the years really before the consolidation of the approach that I described. It's important to note that in the late 19th, the early 20th century, probably the best sort of mechanism for actually cohering the country was that project of territorial expansion. It wasn't necessarily a national text. Most of life was taking place at the local level. And it was the experience of settlement and expansion that incorporated new migrants into a project that can be thought of as American, that it transformed American life. And what marked the end of the 19th, early 20th century was the fact that all of the basic elements of collective life through the first 100 years really were now sort of up for grabs in a way that produced profound social conflicts. So there's the Civil War and the cataclysmic implications of the Civil War in terms of just the sheer casualties, but also the effects of the Civil War and Reconstruction, which leads to the move of black people from bondage to freedom, but then again in the post-Reconstruction period, back to new forms of servitude and bondage. There's large-scale migration from Europe and elsewhere that that creates a situation where upwards of 15% of the population is not born in North America. There's also intense forms of industrialization that are producing new kinds of class conflict within the society and within those that have been included based on racial grounds as properly full members. And at the same time, the frontier is closing. There's no new land really to settle in the way that had marked the terms of collective life. And all of this leads to rippling questions about what's in fact going to cohere the society. At this time, you have the first centennial. So in 1887, and this is really where the book begins. In 1887, the first centennial of the Constitution takes place. There is a private centennial commission that's attempting to get money, support, enthusiasm to celebrate the Constitution. And this is a kind of harbinger of what's going to take place over the next half century. They go to Congress to get funds from Congress. Congress isn't interested in providing funds. They try to come up with poets that will talk about the greatness of the Constitution in verse. They're debating which poets to ask. They decide that Walt Whitman's a little too out there, not going to ask Walt Whitman, but the poets they do ask decline. Many of the people they ask to show up in Philadelphia to attend the events around the Constitution don't go. Folks from the South especially have no interest in attending. I'll say a little bit about why in just a moment. Ultimately, it's not a total fiasco because the state of Pennsylvania gives money and the business community in Philadelphia gives a ton of money. And we can think about why. Pennsylvania understands the Constitution's drafting not as a national event, but an event of local state pride. This is one of the reasons why folks from other states are not particularly interested in celebrating at Independence Hall in Philadelphia. The business community gives money because to the extent that the Constitution has become part of new debates, it's really debates over labor legislation, social welfare programs, and that it's very much increasingly associated, the text of the Constitution, with the courts, and the courts are understood as business-friendly, that are interceding to strike down laws that have been passed on behalf of labor in these class conflicts between business and labor. Now, ultimately, you have events in Philadelphia. The president, Cleveland, comes and gives a speech. But nonetheless, there's a sense that constitutional support seems to be something that's contested. And in fact, E.L. Godkin, who is the iconoclastic Republican founder of The Nation magazine, writes in The Nation, it's not a surprise to him why there's been so little interest, seemingly, in these celebratory events. And that's because the Constitution was supposed to be that compromise that Daniel Webster articulated. And on that score, as a compromise between the states and the federal government, and as a compromise over the question of slavery, the war itself spoke to its profound limitations. And if you just think about that historical moment of the various communities outside, essentially, of the legal establishment and of business communities, it's really hard to find other pockets that would have been unabashedly supportive of the constitutional system. The closest that you're going to get to a defense of the Credal Constitution on the terms that I articulated a little bit ago would have been within the black counterpublic, because it's really black activists and folks like Frederick Douglass that are making the argument that with the 14th Amendment, the Constitution now concretely fulfills the principles of the Declaration. But again, remember that their experience isn't one in which Reconstruction just succeeds. It's an experience in which increasingly the country is marked by new forms of bondage, new structures of Jim Crow that reassert the essentially racially restricted nature of the project. And so it feels to many black people like they might back a Credal Constitution, but the rest of the society, and perhaps the white majority, does not. And that creates real ambiguities of political attachment within black politics. And then if you go to the South, you have ex-Confederates that had no interest even in sending people to celebratory events in Philadelphia. If you think about labor, the labor movement is increasingly making arguments about the extent to which the Constitution might be a counter-revolutionary document. And indeed, in many ways, between 1887 and the late 1930s, the dominant popular conversation about the Constitution is one that's highlighting the extent to which the Constitution might stand as a roadblock in various ways for principles embedded in the Declaration. Indeed, this is a period in which there is broad-ranging reform conversations about the text. It leads between 1913 and 1920 to 4 constitutional amendments that get implemented on some of the most important issues of the day, like the direct election of the Senate, women's right to vote, temperance and prohibition, and then the federal income tax. These are all big social issues. Another constitutional amendment almost passes banning child labor. And it speaks to a cultural context in which perhaps the dominant academic as well as reform position is that key elements of our constitutional system, either through a formally new text, a second convention, or informally through improvising changes, will have to shift to look a lot more like both democratic practices, frankly, at the state level, and emerging forms of parliamentary and mass democracy globally. I'm going to highlight here one of the strands of argument. Jonathan mentioned that in the book I really try to take time with long traditions of constitutional argument that have typically not been part of our story, that come from Black, indigenous, feminist, labor, and immigrant politics. But here I just want to note Black politics in let's say, the first third of the 20th century. You had figures like Du Bois, like Hubert Harrison, that are arguing that the problem, and a lot of this should sound familiar, the problem of the constitutional system is the essential unit of the state. And what this essential unit does is that it makes it very, very difficult for communities, especially those that don't have material resources, so especially thinking about Black community, but also white workers and those that are poor, whose only resource is the vote, to be able to actually shape national policy and by extension state and local policy. And instead, the centrality of this state unit means that folks with a great deal of resources, and so for Du Bois, he's thinking especially of the resurgence of a white planter elite in the South that's able to hold on to the land and control the institutions of government, that those with a great deal of resources can use the interstices of the existing federal system to be able to impose their ends, even if those ends are deeply unpopular. And so Du Bois and others argue for a basic shift in how Americans imagine their Constitution. They say there are many different ways of thinking of constitutionalism. If constitutionalism is about marrying, in some deep sense, rights with a principle of democracy, we could have a constitutional system that, in a sense, doesn't totally collapse the gulf between the Constitution as a higher law and legislation as ordinary law, but makes the Constitution a more pliable instrument for the exercise of popular commitments. In other words, simplify the amendment process so that you can change the text and include various types of positive socioeconomic rights, alter the basic units, administrative units of representation so that those units more clearly map on to population centers and also especially to interracial population centers in the South that have been contained by the pushback against Reconstruction. Shift the court system toward a structure in which various kinds of court reforms mean that you don't have life tenure for a small number of judges that don't have any kind of ethics oversight, and on and on and on. What they're imagining, in many ways, is what becomes standard in the second half of the 20th century across many parts of the world, which is systems of constitutionalism that combine forms of parliamentary and proportional representation, even if they mix a parliamentary and a presidential system, with a much more extensive constitutional text. So today, for instance, the average length of a constitution around the world is 20,000 words. The American Constitution is 7,000. The Indian constitution, for instance, is 150,000. State constitutions tend to be significantly longer. States like Alabama, for instance, have upwards of 300,000 words in their constitution. But even if one doesn't want to go all the way to that length, there's a way of imagining a constitution as a document far more capable of having detailed policy commitments, expansive rights provisions, and a more flexible way of relating between the legislative and the judicial branches. And these are all the thoughts that are percolating during this period. And in fact, in a way, they're probably best exemplified by the dominant sort of historical or academic book on the Constitution in the first half of the 20th century. And that's Charles Beard's An Economic Interpretation of the Constitution, which reads the Constitution as written against some of the democratic impulses that were unleashed in 1776, and that is understood as a background text for them thinking about these various types of reform. All right, so how is it that this changes? And here I'm going to move much more quickly. The argument that I make in the book is that we have to appreciate the extent to which the U.S. emerges as a global power and is starting to think about what is it going to do. Leaders are wondering, what is American power going to look like at just the moment when the European empires are themselves collapsing due to 2 world wars that really destroy the old imperial system, and then following World War II, just because the empires really can't maintain control over various territory, the mass global decolonization of the world. The initial thought that American elites have, and you see this following the Spanish-Cuban-American War in 1898, is that if the frontier is closing, then perhaps the best way to be able to actually continue to expand the pie for insiders is by just replicating a global empire on terms that are not unlike the British or the French. But almost immediately, Americans find themselves confronting, in the Philippines, in Puerto Rico, and elsewhere, when they try to hold possessions, not deeply like self-assertive, non-white populations that are developing their own nationalist independence movements and conceive of themselves as part of a global decolonizing world. And just as a condition of being able to maintain some degree of control in these locations, what American officials start doing, and it's really key that initially these are Republican officials, is they start returning to the anti-slavery discourse of the Civil War and Reconstruction that folks like Lincoln or Douglas had articulated, that the Constitution fulfills the principles of the Declaration, and argue that the U.S. might have a special role to play. When the U.S. is in a place like the Philippines or even Puerto Rico, it's not there to engage in permanent extraction of resources. It's there to promote the principle of constitutionalism because that's actually the bedrock of the national project. And that its principle of constitutionalism is a fulfillment of its Declaration of Independence, which makes it exceptional and unique, and means that when the U.S. exercises power on the global stage, what it's effectively doing is spreading an account of democracy and preparing countries that may not, in fact, be ready, quote unquote, for it, for some account of self-government. It might need to intercede, to reconstruct states, to reconstruct economies on a stable footing, but all in service of a constitutional agenda. So interestingly, you start seeing in the Philippines, in Puerto Rico, the replication of the U.S. Constitution in the terms that are established for partial self-government. So the development of organic laws to govern the territories that have a Bill of Rights, that has a House of Representatives, a Senate, a Supreme Court that looks and reads like the U.S. Constitution. And then when the U.S. goes to war in World War I, the Constitution is a central element of the project. So the very first National Constitution Day takes place during World War I. It's promoted by an organization called the National Security League. And the claim was that celebrating the Constitution is key during wartime because the reason why the U.S. is at war is to protect and promote the constitutional system. At a time when there's still real uncertainty about whether the U.S. should have a large standing army, should have a global presence. Isolationist politics is a very powerful presence in American life. The argument for American global authority becomes closely associated with the constitutional text. And you see the mass development of kind of movement politics around the Constitution. This is also the period that initiates the passage of laws at the state level for the instruction of the Constitution in public schools, oratorical competitions on behalf of the Constitution. It remains contested because there's a great deal of uncertainty about whether or not the institutions actually promote democracy. The next really key moment is the New Deal, and the fact that the court capitulates to New Deal policy essentially produces a fair amount of buy-in that even if this is not the ideal infrastructure for governance, at the very least it's not a roadblock, a permanent roadblock to policymaking. One should note that New Deal successes were predicated on massive supermajorities, the likes of which really are not feasible in contemporary American politics. In 1936, FDR had effectively 80% of Congress behind him in terms of pro-New Deal politicians that were elected because of the strength of the labor movement and essentially the strong working class backing for the New Deal at that time that were able to overcome the roadblocks to the constitutional system. That then leads to the next really huge outpouring of constitutional support, which is the lead up to World War II. The Bill of Rights had not really been celebrated as 10 amendments that are foundational to national identity in previous anniversaries, 1841, 1891. In fact, you still had states like Connecticut, I'm not 100% sure about Massachusetts, but it might even include Massachusetts. There were 3 states that had not ratified the Bill of Rights in 1938. But between 39 and 41, you have mass rolling celebrations of the Bill of Rights. And here, this is the identification of the Constitution as not primarily about the constrained system of representative government, but instead as about that Bill of Rights. In fact, FDR gives a speech a week after Pearl Harbor is bombed to celebrate the ratification of the Bill of Rights December 15th, 1941, and says that the Bill of Rights, like the Magna Carta, is among the greatest, if not the greatest, charters of human rights and human liberty in world history. So reconstructing the meaning of the Constitution now as a civil libertarian document that ties to why the U.S. should be at war and why the U.S. is fundamentally different than Nazi Germany here specifically. I should note, and this is a kind of caution about the story of the way in which war-making in American power is tied to constitutional meaning. There's something profoundly worth celebrating about the invocation of civil liberties as bedrock to our constitutional project. But it's nonetheless the case that in California, the very folks that are participating and promoting these Bill of Rights celebrations are also moving toward the internment of Japanese Americans and making the argument that the only way you're going to get civil libertarian protection is if folks that are threats to the body politic are fundamentally excluded. And it's that combination between the needs and objectives of the security state and the culture around constitutional veneration that we see time and again that requires us to take pause and think a little bit about what some of the consequences of unalloyed constitutional worship might be. All of this really finally comes together during the early days of the Cold War, where now for the first time in a sustained way, the Supreme Court and the checks on representative government are reclaimed, because the argument gets made that the reason why the U.S. did not go down the path, especially of the Soviet Union and also of Nazi Germany, is because it's constrained populist or majoritarian tyranny. That the U.S. had its own moment with Joseph McCarthy, and it pushed back against it because of the nature of its institutions, the checks and balances, and you have a rallying around the court as really centrally associated with the meaning of the Constitution, where a half century earlier, there's strong associations of the court with the Constitution, but it's a negative association. Now in the 1950s, the two things are linked, but it's as proof of the kinds of insulated institutions, anti-populist institutions that preserve against tyrannical majorities. we can talk a little bit about how accurate that might be as an assessment of American politics in the mid-20th century, or more recently. If this is the historical narrative, and here I'll end, what does this mean for the present? The book attempts to do a number of things. The first and probably most significant intervention is a scholarly or an academic intervention. And I want to make arguments that highlight, one, a feature of our scholarly conversation about the Constitution. So this is one takeaway. If we were having a discussion in an academic space about the US Constitution 100 years ago, that conversation would be taking place in history departments, in political science departments. The most well-known scholars of the Constitution would have been people like Charles Beard, historians, political scientists. And the reason why is because the taken for granted assumption is that a constitution is a system. It's not just a text. It's not just a legal document. It's a system that intersects all of these institutions. And in order to understand it, you have to see how these institutions operate against the backdrop of social movements, social forces. And if you treat the Constitution just as a lawyer's document, in which it's studied exclusively through the doctrine of the Supreme Court, you're going to miss 90% of what the constitutional system is, and you'll probably also misunderstand what's going on in the court. One of the things that happens in the second half of the 20th century, and so this is the way in which the book is a critique of my own field, is that constitutional law professors, folks like myself, become the privileged interpreters and experts on the Constitution. That's only possible in a context in which effectively all of the big picture questions of state and economy have been put to the side, and that you assume that whatever happens on the court is co-equal with what happens in the Constitution, and also you accept, either explicitly or implicitly, this story about the court as the only real safeguard of the Constitution. Under those circumstances, then the Constitution becomes reduced, effectively, just to the doctrinal disputes that take place on the court. And indeed, the entire conversation we have about the Constitution is effectively turned over to judges. Regardless of the ideological position of those judges, this is a small range of folks with a relatively limited account of what the appropriate reform imagination should be, what kinds of conversations we should have. And so the book is an effort to say, not only should we have a broader constitutional memory, broader sense of what the constitutional story is, but it's incumbent on us now to collectively reclaim, as a scholarly matter, but then also as a popular matter, what counts as a constitutional conversation, who serves as a constitutional actor. And this gets to the second scholarly point, which is a lot of the book is working through the arguments about the Constitution made by non-judicial actors, by non-lawyers. And the reason is that, especially at a moment in time where the debates we're having about the Constitution are not really about how to interpret a particular clause. They're about, what does it mean, finally, to live in a multiracial democracy? The arguments of all of those figures, take somebody like W.E.B. Du Bois, part of the canon in many fields, but not a constitutional thinker typically treated as one in law schools, even though he wrote 2 books on the Constitution, Black Reconstruction and Color and Democracy. Those folks that are thinking more comprehensively might actually have more to tell us about how to confront the present. And then this will be where I end, which is, it also speaks to a kind of political predicament that we face, that tension between the politics and the culture. The first thing is it forces us, for all of the profound achievements of the 20th century rise of modern veneration around the Credal Constitution, to think too of what some of the limitations have been. And I'll just note too, we're living in a moment where we might very well end up electing our second Black American president, first president that's a woman. And this speaks in a sense to an inclusive story that's transformed collective life. But it's at the same time where the country has been roiled over the last decade by protests arguing that the country is experiencing a new Jim Crow, marked by how race and incarceration shape people's lived opportunities. And that, in many ways, I think, is a function of the culture that ended up being promoted around the story of the U.S. as free and equal from the founding, which was a way of both transforming the country through a narrative of shared change, but also, at times, a refusal to actually engage with what might be persistent structural inequalities that can't be covered or can't be articulated just through a language of steady improvement and completion over time. Secondly, it's not a surprise, I would say, that we're dealing in the present with arguments about presidential impunity, about the rise of an imperial president that long precedes recent contemporary politics. It goes back the last half century, whether or not presidents are unbound and how they exercise their own authority. Just as we've had this culture that really intensely defends the Constitution. That seems like a tension, but in a way it's a perpetuation of precisely how national security ethics at times have corroded even the civil libertarian values that were supposed to be the very foundation for why the U.S. was worthy of exercising authority on the global stage. And we have to make sense of that tension rather than simply wishing away one side of it and saying that just reasserting constitutional support can avoid the problems of security excess. And finally, it then means that in a moment like our own, where in many ways things feel unsettled, perhaps as unsettled as they did 100 years ago, that we have back on the table some of the most troubling elements of the American historical past, and I think we have back on the table some of the most hopeful and liberating elements of the American historical past. And what that means is that we should take this as an opportunity to break free from the collapsing of constitutionalism, the idea of living in a constitutional democracy, which I would say is absolutely worthy of support, with the presumption that the only way you can have a constitutional system is by reasserting again a kind of unquestioned faith in this Constitution and the set of institutional practices that it's produced. And that means if we take those two things apart, really thinking about, well, what is the good and the bad of our constitutional legacy? What is it that we want to keep? What is it that we want to change? And what would be the social conditions that would make the change we seek possible? I'm sorry for going long, but thank you very much.
Thank you so much. I will kick off the conversation with a couple of questions while you in the audience may prepare your own comments and questions that we'll open up to you in a moment. So thank you so much. This was really a wonderful tour de force of the ground that the book covers. I'm interested in exploring a little bit this language of veneration, exaltation, that you suggest is as obscuring or blinding as it is revealing. And I'm curious, actually, in the context of the political science literature on national identity. And so there are a couple of authors, actually historians as well, whom we read in our introductory classes, like Eric Hobsbawm, who talks about the importance of tradition in national identity and the invention of tradition, a kind of concession that it's an invention. And then the other, of course, is Benedict Anderson, who introduces the notion of an imagined community as a central driver of cohesiveness of the national community. So where do you ultimately land on sort of the potential role of the sacred, of the mythical, in keeping the country together as it faces some of these rough waters you just referred to?
Yeah, so thank you. So the first thing I'd say is that in many ways, I really see the book as in conversation precisely with those texts. So that I've written a book on the Constitution, but I'm most interested, in a sense, in the American version of liberal or civic nationalism. And what I'm highlighting is the extent to which this particular constitutional text ends up becoming really central to the civic nationalist story the country ends up telling about itself. And I should say, I found this striking because there are ways in which the American experience in the 20th century is frankly just like many other countries, and there are ways in which it's different. So one thing that happens over the course of the 20th century to France, to England, to the US, to all of the various kinds of Euro and American imperial powers, is that they end up rejecting an account of national identity that we think of as like straightforwardly ethnic nationalism. Like it's an ethno-racial account of belonging. And this has a lot to do with the collapse of the imperial system, global decolonization, the ways in which those arguments just really don't fly in the second half of the 20th century. And so in this way, the US is very similar to these other projects. But what's different is that the US, not totally alone, but is relatively novel in linking an account of civic nationalism to the constitutional text. That it's the text that's the thing that underscores or highlights what it means to have a liberal nationalist project. And you can just think about this by juxtaposing it with France. So France has had many different republics, many different constitutions. France also, during these same years, moves from effectively being a project organized in ethno-racial terms to one that embraces an account of universal civic national identity. But it locates it in the revolution. So it locates it in the Republican tradition. Like if you talk to people in France, they don't march under the banner of the 1958 Constitution. It's like, actually, you just have to read the text of the Constitution and that's what we're supporting. No, it's a different way of thinking about cultural identity. And so I was first interested in what have been the strengths but also the drawbacks of the fact that in the US, we don't peg it just, for instance, to the Declaration of Independence, which one could imagine, or to broadly a revolutionary tradition, or let's say to a story about the Civil War and Reconstruction. These are other ways that we could narrate the national project where the country is experiencing a second republic and we hold firm to the principles of the second. Instead, we narrate it as a single, unbroken national project tied to the text of the Constitution. And then that gets to the second part of your question, which is, while I view social cohesion as a really significant issue for any society of numbers, and especially for a nation state like the US, I tend personally to be more skeptical of the idea that it's really this text that's actually done the cohering. So, for instance, I would say the thing that did the most to cohere American life under some account of civic membership isn't the text of the Constitution, it's the successes of Reconstruction and then especially the Civil Rights Movement, the labor movement from the 30s to the 50s, a set of transformative social changes that took place between the 30s and the 60s that were oftentimes pressed by people that rejected the Constitution, or even folks like Martin Luther King that are today very easily incorporated into a Credal constitutional story, but are actually quite skeptical and had a much more complicated relationship with national narratives. And the thing that actually cohered the society was that the material problems, the social problems that people experienced were solved through, at least partially, were partially solved, ameliorated through the country's political institutions. Constituents, groups that may view themselves as fundamentally opposed in lots of different ways, were nonetheless able to find common cause behind social changes that had transformative effects on the country. And I worry that a lesson of some of the scholarship, but a lesson especially in politics today, is that the way you solve the problem of social breakdown is by just being incredibly charismatic about the story of the country. And that somehow, if you can just convince people to believe the narrative, the society will cohere. Rather than the society has cohered in the past because people, even if they had fundamentally different views of the country, even competing views of the country, found common cause, to pursue social ends, and the institutions functioned to make sure that those problems were at least partially solved.
Thank you for that. My other question that I have for you before opening up to the audience has to do with a specter that lurks throughout the book, which is that of the people, right? There are the masses, there is popularity, popular opinion that is occasionally referred to. And so I guess one part of the question is, this is a book that speaks to elites on the one hand, who suffer from an excess of enthusiasm or veneration, whereas one of our central problems seems to be the apathy of the rest, right? And so do you have a prescription in here for what afflicts the masses, in a sense, in terms of, underdeveloped civic education, underinformed participation, and not, say, an excess of respect?
So one of the more perhaps controversial arguments in the book, and this is, I think, an argument that's really specific to the US, so I'm not going to generalize this claim, is that in the US, the problem of rights restrictions, various kinds of crackdowns on communities that you'd want to have fully incorporated within the polity, has not really been a problem of tyranny of the majority, like of mass overstepping of various kinds of institutional constraints. It's been, and this is the title of the Ziblatt and Levitsky book, it's been the problem of tyranny of the minority. In other words, that if we just look at the periods in American history where you've had sustained and extreme rights deprivation, it's because a relatively small number of elites, and we can think about the antebellum South, or the pushback against Reconstruction, or the systematic denial of women right to vote, as well as a variety of other kinds of basic rights. This has been a story of empowered elites using the infrastructure of the American constitutional system to actually impose their ends over and against a majority. And in fact, the periods in which American life has seen a flourishing of more expansive rights, and here I would include things like the New Deal period in that mid-20th century era, it's tended to be one in which you've had large-scale mass mobilizing. It's large-scale mass mobilizing that has primarily been the condition by which we've had meaningful change in a rights-respecting direction. So it's not the case everywhere, but in the US, rights and mass democracy have interestingly coincided. And so then that actually raises some pretty profound questions about how to think of the present, which is, I worry that an effect of our constitutional system is that it, along with the basic issue of to what extent is it actually democratic, it makes it very difficult for Americans to believe in a non-cynical way that if you elect people to Congress, the basic problems that you have will be solved through decisions made by our political institutions. In other words, there's a kind of paralysis that makes the foundational elements of what I described as how social cohesion emerges. Social cohesion emerges when groups, despite their difference, believe that there are mechanisms to have their problems solved. But if you live in a society in which, this is one of the many binds of the book's title, where it's very hard to believe that the basic institutions will solve your primary problems, that creates these cycles where there's excitement, enthusiasm, you elect people to office, nothing happens, that promotes disaffection, apathy, and then various kinds of lurches, where then you might invest in figures or politicians or social movements and forces who promise to break things up or to shatter the status quo in ways that have no clear political direction. And in a way, this reminds me of something that Norman Thomas, one of the founders of the civil liberties, the ACLU, and then also a presidential candidate on the Socialist Party from the 20s to the 40s, but a very committed civil libertarian, said when he defended the need for court reform in the 1930s, he said, even more than the worry about FDR having too much power in this moment, the thing that will actually promote demagoguery and the rise of dictatorial power in the US is if the institutions seem like they can't actually solve problems. If you have a court, for instance, that will permanently block massively popular legislation. And so I think, in a way, when we diagnose problems of apathy in the present or the problems of political disaffection, we have to see how these things are not like just permanent objective facts about how any population behaves. They're absolutely connected to the infrastructure of institutions that exist. Are there strong, as Tocqueville argued in the 1830s, intermediate institutions that connect people in civic association from parties and unions to other forms of organization, including churches? And do these institutions provide meaning for people? And do they provide pathway within which they can actually operate politically to change how collective life operates? To the extent that that's not the case, then you're going to have all of these problems about what to make of a disaffected, unorganized mass that's far more likely to engage in the kinds of destructive lurches we might be worried about.
Thank you. That's both these excellent answers. Really, it's great to listen to you talk about these issues. I love it. I know that there are questions and comments in the audience, and so I'm happy to open it up. I see three right here. Let me start with Professor Madoff, and then go to Casey Perzer, and then to the young woman in front.
Great talk, and you just made me unbelievably sad again about the Supreme Court's refusal to take the problem of gerrymandering seriously, because I'm like, oh wait, we could have something that actually put that piece back in there. But my question for you is about the how you see the ERA in this story, and this, you know, I could imagine 5 different ways, but I'm sure yours is going to be much more thoughtful.
Yeah, so the ERA is the Equal Rights Amendment, which emerged as an argument made by feminists in the 1920s after the passage of the 19th Amendment, providing women, in that context, white women, the right to vote. And what the ERA did is it was meant to be a kind of parallel to the 14th Amendment Equal Protection Clause, so establishing that under the law there would not be discrimination on the basis of sex. It has a moment in the 1920s where it becomes central to women's movement organizing. It largely disappears from the political discussion until it comes back in the 40s and 50s, and then becomes a centerpiece of a range of arguments that second-wave feminists make in the 60s and 70s. Second-wave feminists argue at that time that the ERA has to be part of a broader and more comprehensive agenda to alter the terms of gendered life in the US. The central thing that many feminists in the 60s and 70s were concerned with was the gendered division of labor, the sense that women were consigned without choice, essentially, to work in the home in a setting in which they were also systematically denied various kinds of opportunities in the public sphere. It might be the case that at that point, women and then post-1965 black women, white women and then after 65 black women had the right to vote as well. But there were all of these ways in which what Pauli Murray referred to as Jane Crow operated in the US. Take, for instance, United Airlines. United Airlines used to fly flights called like executive flights that were just for men. So this would be like business flights for men only. The press club in DC did not allow women to be members. So that there was a kind of systematic discrimination. And the thought was the ERA would be a constitutional tool to get rid of all of these legally enforced forms of Jane Crow, and it would go hand in hand with other commitments, including commitments around childcare, around questions of reproductive rights, so a set of commitments as a whole. And then what ended up happening is that there was a moment where it looked like the ERA was in fact going to get ratified. At the high tide of the women's movement, 35 of the 38 states that you would need for ratification supported it. But then there was a pretty profound and sustained backlash against the politics of the women's movement that ended up feeding really the most dominant social movement of the last, let's say, 30 years of the 20th century, which is social conservatism, and saw the ways in which the politics around feminism had disrupted what were seen as traditional forms of family. And ultimately, what ended up happening was that the push for universal child care, which also got very close, like passed the House and the Senate, Nixon ends up vetoing it, meant that very little of the actual overarching agenda of second wave feminism got implemented, except even though the ERA did not become ratified as law, lawyers succeeded, this is Ginsburg and others, in reading effectively the ERA into the 14th Amendment's Equal Protection Clause. So many of the kinds of ends that one would want through the ERA were pursued through the 14th Amendment. Now, in the wake of movement organizing in the 2010s, there was a second push to see if you could actually get the ERA ratified. And today that's meant that you're now over that threshold, but some of the states that have now ratified the ERA have done so after a time limit has gone off, so that you're supposed to have done it by the early 1980s. And it means that the status of the ERA is contested. It's not clear whether or not, I mean, most likely this means that it's not going to be thought of as like an additional amendment. And it leads to like two things that I'll just say about it to close. The ERA speaks to how incredibly high the bar or threshold is to new amendments. That in the US, the constitutional amendment bar really outstrips anything that we see around the world. So you need 2/3 both houses and then 3/4 of the states. And so you could have massive support and still not get things amended. Most countries might require, has to pass Congress, and then it goes through a referendum. Maybe you need a supermajority support, so like 60%. The fact that the ERA is not a separate bit of text underscores the difficulty. The second thing is it highlights how so much of American constitutional law ended up just moving into the courts. It became a debate not about changing the text, and indeed like the kinds of mobilizing that you can develop around changing the text. It became a debate about convincing the judges. And there's been times when that's been more successful, and there have been times when that's like frankly less successful. And there's a real question about to what extent did the jurisprudence that Ginsburg and others stood for from basically the 70s to the 2000s, will that actually remain with the current Supreme Court? And I think that speaks to, in my view, a basic problem with imagining that the court is going to be the only path, or that interpretation is the only path for constitutional change. It really highlights the need to avoid having a constitutional system that just funnels all constitutional debate into the courts, because then, even if you like the judges, you're just beholden to that judicial sentiment. And that's especially a problem in the US when you have such a small court nominated and confirmed through a very particular process where those justices are serving for life.
Hi, I'm Casey Perzer. I'm a PhD student in the political science department. I do federalism and public law. I have a question about civic education and constitutional veneration, because on the one hand, I certainly agree with your position that the Constitution took on a semi-mythic role in the late 20th century. On the other hand, it seems that that veneration is supplemented by a lack of popular knowledge of what's actually in there. Anecdotally, I'd say through being a teaching assistant or serving or to lead a seminar at BC, I'm troubled sometimes by students not understanding what's in there or just not knowing what's in there. And I'm wondering if there's a relationship between veneration, saying, oh, it's the best thing of all time, we just got to respect it no matter what, we should spread it around, and not paying attention to the details or leaving it to the lawyers.
Yeah, so I mean, I think this is a huge problem. And it's a huge problem because of precisely the way in which constitutional support is tied to our basic national story. So if you have this vision of a perfect text, but there's very little conversation about, well, what concretely does it end up generating as a set of institutional practices, then it means that you can have a culture of continually sort of regressing back to, well, we have to hold firm to X, Y, Z, without necessarily having the serious conversations about what type of constitutional system we want. And I should say, I don't want to be too cynical about this, but it should be noted that when civic education around the Constitution really gets off the ground in the years around World War I and post-World War I, the civic education is of a particular sort. It's not what we might imagine, which is it's not about like, well, let's really get into the nuts and bolts, either at like the high school level or even oftentimes in college, but let's say especially at the high school level, in like the nature of the constitutional text, or it's not a critical engagement. Let's think critically about the values here, whether or not they're being supported. It's very much an exercise in recitation. So one of the things that I ended up looking at in the book was some of the early constitutional education, basically like books that were assigned, school books that were assigned. And they tended to be sort of yes and no questions, or a series of questions that would have a simple answer. Like, what is the guardian of American liberty, the Supreme Court? Like, what's the balance wheel of our constitutional system, checks and balances? What is like the greatest constitution written, the U.S. Constitution? I mean, it's a very much an exercise in ensuring a kind of loyalty to a project rather than thinking concretely about the document. And it's not a surprise why, because in the 20s and 30s, there's a lot of uncertainty about whether or not the actual institutions are functioning well. And so I do think, on the one hand, one would be hard-pressed to expect any society to really know the internal dimensions if you're doing general opinion polls of like what's in the Constitution. This is the same case in like South Africa, is a country that really venerates its own post-apartheid constitution. Also, the like knowledge of the actual text is not particularly high. So on the one hand, like it's not surprising. On the other hand, I do think that it's in part a creature of how various generations of constitutional education actually operated, and it feeds a specific problem in the present, which is general symbolic support because of how it's tied to the national project, without a rigorous account of like, how much ownership do we have over these institutions, and do these institutions serve us?
Hi, my name is Abanti. I'm a senior. My question is, how has the U.S., or how differently has the U.S., if different at all, as a lead actor in the war on terror, promoted constitutionalism in the Middle East compared to, for example, in the Philippines or Puerto Rico?
Yeah. So, this is a real question about, depending on your perspective, whether or not we're seeing breaks or continuity in American practice. So going all the way back to the Philippines, there's a strong commitment to constitution writing projects and constitutional consultation as part of what it means for the U.S. to assert power overseas. And so you see this in the genesis and writing of organic documents for Puerto Rico, the Philippines that I mentioned. You also see it domestically, really starting in the 1930s, with constitutions for Native American nations. So there's a process in the US in the 30s where the US starts providing recognition to Native American nations with a fair amount of internal self-government, though still with the federal government as the ultimate authority that can intercede and reconstruct Native American life. As part of the process toward recognition, even though it was not required, there was a kind of expectation that Native American nations would write their own constitutions. And the Bureau of Indian Affairs actually came up with like a model constitution that even if it didn't say, hey, use this document, ended up being replicated over and over and over again. And we see a version of that play out in interesting ways. We see that in the way that the US promotes within its own sphere in Germany, constitution writing. This is after Germany gets divided up following World War II. We see it in the Japanese constitution that MacArthur has a central role in effectively writing. And you also see it in the rise of law professors and legal experts as consultants that the State Department sends to various parts of the world to give advice on how to write their texts. Now, oftentimes, the US is not imposing necessarily constitutional outcomes. And indeed, various countries are just like, you know what, we're not going to follow the American model. But it's no doubt the case that the US has particular features that they time and again tend to emphasize. So they tend to emphasize like federalism, checks and balances, property rights, certain sort of foundational elements of a constitutional system that would go hand in hand with the linking of US markets, the linking of state and private actors. And then post 9/11, very much you see a more full-throated return of what had been, I think, a kind of classic way that the US understands its authority. So the US is centrally involved in viewing what it's doing in Afghanistan and Iraq as not about colonies, but about deposing unstable leaders, reconstructing the country and leading it on a path toward independent self-government, and writing a constitutional text is really key to this. And so you have central figures in the US government, law professors that are involved in the writing of the Afghan constitution, the writing of the Iraqi constitution. And one can wonder about the extent to which these were successful enterprises, or they faced many of the same problems of these previous ventures. The most significant of those problems, you'd say, is that it's not really clear whether or not these exercises had deep mass support within social bases in the society. That even if they brought together various kinds of hand-selected elites to then come up with these texts, the US is not dictating the text. The texts oftentimes did not have extensive social buy-in. And so it ended up, rather than reducing social conflict, just becoming another site that froze disputes, generated new forms of conflict, and then required yet more American intervention. And in that way, even though there's an explicit desire to say this is not about like the bad old imperial forms in Puerto Rico and the Philippines, there's still continuities with the problems of these projects of constitution promotion.
So one final question from Chandra Mahampati, and then we will break for
Thanks so much for your talk, and I very much appreciate the parts of the book that I've been able to read, and I really appreciate your periodization of this commitment to constitutionalism. And my question has to do with the 20th century point of departure and the emergence of what you call Credal constitutionalism, and how you pair that with the emergence of America as a global power. And I'm wondering if you could perhaps clarify what function the language and idiom of Credal constitutionalism is playing in the exercise of global power. Why did American elites need to go through that itinerary, that textualism, that textual emphasis, to frame its positionality in the world, when the world out there couldn't care less about our Constitution, couldn't care less about these things? And as an earlier question raised, a lot of Americans are absolutely clueless about the Constitution. So what is the actual function of that Credal constitutionalism in the exercise of global power?
So let me take two elements of it slightly apart. So one is why the Constitution as a story of American power, and then the second is the text, like the focus on a kind of literalism that seems to mark so much of contemporary and recent American constitutional life. So on the first, the argument that I make is that the US effectively, and this is in the context of the two world wars, and then especially after World War II, becomes the dominant global power, but in a very different world than the one that was essentially ruled by European empires. In other words, those empires have collapsed. It's just materially almost impossible for England, France, Belgium to be able to hold on, because their countries have been just like ravaged by war, to all of these global possessions, and you have intense anti-colonial national movements. And so this means almost as just like a structural fact about the mid-20th century. Whatever the world is that the US is going to become a dominant player in, it's not going to be one organized around empires. It's going to be one in which you have fractured former empires and all of these newly independent nation states. And that means that the US, which culturally, in many ways, is just an extension of those European empires. So in the early 20th century, Teddy Roosevelt sends part of the Pacific Fleet on a tour of Australia and New Zealand following Japan's victory over Russia. to say that just like South Africa, New Zealand, Australia, the US too is white man's country. Like, this is the way of thinking about American national identity. That's an argument that really isn't going to make sense of the new global community. But there are these other traditions and strands that are tied to the anti-slavery project, tied to the Civil War story, that say, well, the US isn't actually just like all these other European empires. It's the first anti-imperial project, and it's a project that's been committed to principles like the Declaration, and concretely to this text, which is an infrastructure for governance. And so the Constitution becomes a way to say the principle of American power on the global stage in this post-World War II moment, and there's a long preceding history, is not extraction, it's constitutionalism. It gets replicated through international organizations and institutions, the UN, the UN Human Rights Charter, the construction of the Bretton Woods institutions, and it also gets replicated in the way that the US interacts with newly independent countries. That what it promotes is internal constitutional self-governance. So all of that serves a very clear role, but it's not purely just driven by power instincts. The thing that's really key is that I call this in the first chapter of the book a romance. And the reason why it's a romance is that Americans, white Americans in DC, come to deeply believe this story about their country in a way that has profoundly positive transformative effects for national identity. Americans come to see themselves as similarly situated to Indians engaged in resistance against Britain. And all of this is taking place against the backdrop of a real ideological competitor with the Soviet Union, where Americans have to say that actually Jim Crow practices are not authentically American. And in fact, by the time we get to the 50s and 60s, the argument becomes that the KKK is fundamentally un-American. It's unconstitutional and lawless in violation of the country's basic principles. And this is a really profound inversion of national identity that the constitutional story both serves as a promotion of global power, but as a reconstructive element of domestic politics that sets the stage, for instance, for the civil rights movement. On the literalism, now, this, I think, has a lot to do with deep strains, especially in like Protestant culture and Protestant relationships to the text that go back to the early American experience. It is the case that even on the ground in states, there's this continual practice of writing constitutions, and that direct relationship to the text, I think, has a religious background and foundation. But it's also the case that it doesn't really pick up as the defining way that Americans come to talk about the Constitution until really like the last half century. Because if you tell the story of the first 2/3 of the 20th century, a lot of the arguments about the Constitution is that, well, maybe the framers kind of created a somewhat misshapen document. Maybe they weren't real Democrats. It's not clear if they were consistent with the principles of the Declaration. It's only this mid-20th century recovery of the genius of Madison, of the genius of the founders, and of reading somebody like Madison as a proto-abolitionist, even though he actually was an enslaver, or of reading Hamilton through the story of the US's various projects from the Civil War to World War II, that there's massively greater esteem for the framers. Oftentimes through an idea of a living constitution, that the thing that they bequeath to us is not a specific literal text, but a way of operating constitutionally in the world through these institutions. Once that gets off the ground, that interestingly becomes a very powerful language for the right, for newly empowered social conservatives and a conservative legal movement to say, well, if you love the Constitution so much, let's actually go back to what the framers thought. And it's a very intuitive thing for Americans to think, which is, we love the framers, maybe we should just follow what they think. But of course, if you're somebody that's opposed to some of the racial, gender, and social changes of the last half century, even if the framers' world won't generate a conservative outcome consistent with the new right on every single question, a constitutional imagination that takes its lead from what somebody in 1788 or in 1868 would think is a very different world. It's a much more traditionalist world than the world of the present. And then I should add that the power of social conservatism and the extent to which it becomes infused with various kinds of conservative religious formations then emphasizes again the turn back to text. Like text, this argument about originalism fits within the conservative trajectory of American life, but it also fits within the relationship that initially Protestants, but then not just Protestants, have with texts, and a kind of sacralizing relationship to text in which you read the text, each word, each clause, for meaning that can be divined as like eternal wisdom.
So there are many people who come together to put together even a straightforward single speaker event like this, and I want to thank our graduate assistant, Megan McCoy. I'd like to thank our postdoctoral fellow, Isaiah Sterrett. We have a team of correspondents, of fellows who have been working to advertise, and also thanks to our AV team led by Chris Burns. I'd like to acknowledge our benefactor, Chuck Clow, who is here this evening as well. So please stay and enjoy the reception. Please pick up a copy of Aziz's book. Maybe he'll even sign it for you. And join me in thanking him for this lovely talk.